Good afternoon and welcome to today's Professional Advisors webinar. My name is Deb Shambrook and I'll be supporting the presenters today. Before I hand over to Jason and Simran, some basic housekeeping items. This presentation is being recorded and will notify all registered attendees of its availability in the coming week. All attendees are muted and cameras are off today for the duration. If there are any questions, Jason and Simran will answer them at the end. You can pop any questions into the question function throughout the session today. Finally, a survey will be made available after the session. Please provide your feedback as this lets us improve our future webinar offering. Now I'd like to introduce today's presenters, Jason and Simran, who will present on powers of attorney, tips, tricks and pitfalls. I hope you all enjoy. Thank you.
Thanks very much, Deb, and good afternoon to all of you. Great to see you, and thanks for joining us this afternoon. Powers of attorney, easy to think of as a pretty innocuous subject. And in many people's minds, I think powers of attorney are just those documents you have lying around to make sure that if something happens to Grandad, he's able to get into an aged care facility. But there's a lot more to them, and particularly as we deal with Australia's ageing population, as we talk about complexities of structures, powers of attorney raise significant questions and issues of control, of risk, and of compliance. So we're going to address some of those issues here today. It's going to be a pretty broad-ranging discussion, but also very deep. We're going to talk about some pretty technical aspects of powers of attorney. And really our goal will be to create some awareness of these issues for you and flag some things which you might not have really given much consideration to previously. At the outset, we make our formal disclaimer here, and that is what we're talking about here really is general. And as we go through some of these discussions and some of the case scenarios that we'll discuss, it becomes apparent that when you're talking about these technical aspects of powers of attorney, tailored advice really is very important. So please just bear in mind that what we're talking about today is only general in information, and unique circumstances do require unique advice. So some of the issues that we're going to cover today, we'll briefly address some of the different types of powers of attorney. Then we're going to look at control of trusts and control of companies by attorneys. We'll look at attorneys and a number of issues that relate to superannuation. And then we're going to become a little more practical and talk about specific authorities that can be given in powers of attorney. We'll look at limitations and conditions in powers of attorney. And at the end, we'll conclude with some risk mitigation suggestions for you as you walk with your clients through various situations. So, at the outset, as we talk about powers of attorney, I thought it would be good if we made this a little bit interactive. So let's try this as a show of hands. We're going to talk about a trustee. Now, we're not talking about corporate trustees. We're talking about when an individual is acting as a trustee of some kind of trust. Could be a discretionary family trust, a unit trust, some other fixed trust. And so where you have an individual who's acting as a trustee, the question is, can their enduring power of attorney act on their behalf in relation to that trust? Okay, so I hope the questions are clear, and I hope that this little screen has popped up on your screen. I'm calling for a yes or no result. This is anonymous, so don't be shy. Jump on there. If you think that a trustee who's becoming incapacitated can have their enduring power of attorney make decisions on their behalf, put your answer in there if you think yes, and put your answer in if you think no. Okay, some of you have responded, about half according to my screen here. So I'm going to, and it's a pretty even split. According to my screen here, 45% of you say yes, a trustee's attorney can make decisions on their behalf. 55% of you say no, but half of you didn't answer. So I'm going to take it that half of you don't know the answer or are too shy to have a go. Oh, sorry, I'm jumping ahead of myself. That's okay. Well, hold that thought. We're going to give you the answer in a minute, but here we go. Just a reminder that there are different types of attorneys. You can be talking about general powers of attorney. These are pursuant to the Enduring Power of Attorney Act. Usually they're for a specified period of time or a very specific purpose. The classic scenario that we don't see so often nowadays. The classic scenario was someone who's travelling overseas and selling property and needs someone to sign a contract of sale for them. But there are many other applications as well. Then you have enduring powers of attorney, which are intentionally designed to continue to operate in the event that the principal, the person making the power of attorney, loses capacity. It's also very important to understand, though, when you're talking about different types of powers of attorney, that every state in Australia has its own regime, and depending upon the legislation, they have varying powers. The states all have, or most of the states have legislation recognising other states' powers of attorney, but it can be a blurry area, particularly if you need an attorney to be making particular kinds of decisions that in some states may be permitted and in other states might not be. And then obviously there are also company or corporate powers of attorney, and that is where the company itself makes a power of attorney authorising some person or persons to act on the company's behalf. So it doesn't necessarily make them directors of the company, but it gives them authority to make decisions and to bind the company in particular ways. So all of these different types of powers of attorney have application in a variety of scenarios. And so, bringing us back to where I abruptly left us, the question is, if you have a trustee, so some individual person who's the trustee of a trust, and they lose capacity, if they've made, say, an enduring power of attorney, can their power of attorney take over control of the trust on their behalf? Well, the correct answer is no. For those of you who are following the polls there and hoping for the correct answer, the correct answer is no. And this is a very, very old established principle of trust law, that a trustee's duties are held personally, that the trustee can't delegate their way out of a responsibility and they can't pass that responsibility on to someone else. I've given you there the reference to a very old decision from England, that trustees have no right to shift their duties on other persons. Now, there's a little bit of a departure from that in the Trustee Act. In fact, there are a couple. There is provision in the Trustee Act in certain circumstances for, and they're very limited, for a trustee to make a power of attorney that authorises someone to act on their behalf, but not in the way that you or I would generally expect enduring powers of attorney to operate. The Trustee Act does say that if a trustee is incapable of acting, then the personal representatives of the last trustee can be appointed in the place of that person. So, for example, if Dad is the trustee of the discretionary family trust, then the Act says that his personal representative could be appointed in his place if he becomes incapable. However, under the Trustee Act, a personal representative of the trustee is referred to as, the class of persons includes administrator, but not an attorney. And so you have this situation where if VCAT had appointed an administrator to administer the affairs of that trustee, then that administrator would be empowered under Section 41 to become trustee of the trust. But if Dad has merely made an enduring power of attorney that comes into effect upon his intestacy, then Section 41 and Section 3 of the Trustee Act don't allow that attorney to step into the trustee's shoes. And so that's an important distinction. It's an important distinction, and it's one that may warrant a review of the trust deed. In some circumstances, there may be provisions for automatic appointment of another trustee if the acting trustees become incapable. You want to also be looking at the powers of appointment that are in that trust deed, just to ensure that in a worst case scenario, if the trustee is no longer capable of acting, that there is someone who can either appoint a new trustee or someone who can step into their shoes. If you don't have something like that, then arguably you're going to be having to apply to the court to appoint a new trustee pursuant to Section 28 of the Trustee Act, and that becomes a much more costly and delayed process. So it's one you want to avoid. And maybe as you're talking with clients, this is potentially one of the arguments for having a corporate trustee of a trust rather than having an individual acting. I was talking to someone this week, and they were lamenting that their clients with millions of dollars worth of property were begrudging the additional ASIC filing fee of having a corporate trustee, and it just boggles the mind. But as you're having those conversations, you want to think about how attorneys interact in relation to the control of the trust. So speaking of corporate trustees then, we turn our minds to how attorneys can interact with companies. And once again, I have a poll for you and a very similar scenario. So if we have a director of a company who loses capacity, but they've made an enduring power of attorney prior to that occurring, can that incapacitated director's attorney make decisions in relation to the company? All right, I've put the poll up here again, and I hope that you can see that clearly on your screen. You can put a yes or a no. Can an enduring power of attorney act on behalf of an incapacitated director in respect of company decisions? And the answers are coming in, and some of you might be still popping yours in. It's changing slightly, but at the moment it's 70% yes. Oh, no, it's just changed. It's 50-50 now, 50-50. The correct answer is that it depends. And I apologise, and some of you will have already picked this up. It is a bit of a trick question that I asked because it really does depend upon the circumstances. Section 201F of the Corporations Act provides that if a person who is the only director and the only shareholder of the company cannot manage the company because of their mental incapacity, then their personal representative may appoint a person as the director of the company. And so as you read that carefully, you realise there's a bit of nuance to it. I have seen, accountants in particular reach for Section 201F with a bit of presumption and not always stopping to read it carefully. Firstly, we note that this only applies when the incapacitated director is the sole director and the sole shareholder. So if you have a scenario where, and this is quite common, you might have mum and dad as the equal shareholders of the company, but maybe only dad is down as the director, then 201F won't apply because dad is not the sole director and the sole shareholder. The other thing which is important to note is that the enduring power of attorney doesn't allow the attorney to simply make decisions or sign documents on behalf of the director. 201F allows for the attorney to be appointed as a director. Now, they don't have to appoint themselves. They actually have the power to appoint any person as the director of the company, subject to meeting all the other requirements. But this is an important step because it's not that the attorney can simply go to the bank and start accessing funds and signing off on documents and doing payroll or whatever else they think needs doing. The correct process is that they need to be appointed themselves as directors, and then they can exercise those powers of a director. And so that obviously raises all kinds of issues, particularly if you've got an attorney who is not incredibly familiar with the company's affairs, and the standard warnings and advice that you would provide to a prospective director apply. And I suppose particularly in a real world situation, if you've got a sole director who's administering the company, they may have been in some kind of decline for a period of time before things have become so bad that their attorney has actually had to step in. And so who knows what kind of filings are up to date, what lodgements are up to date, whether BAS and superannuation of employees have been paid. There could be all kinds of outstanding liabilities. And you've got those issues of even potential DPNs that might have been issued historically that would attach to a new director 30 days after them being appointed, regardless of whether they continue to act as directors or not. And so it's a really, really fraught issue, and one that should be addressed very, very circumspectly. And you'd be wanting to warn your attorneys to be careful before they start stepping in and taking control. I mean, you've also got the issues potentially of if they were trying to act and sign off and manage things even without formally being appointed as directors, arguably they'd be considered as shadow directors anyway. So there are a number of issues there to consider. These things obviously apply regardless of whether the company is trading in its own right or as a trustee of some form of trust. And so we come to our next question, and this is perhaps related to the previous two, but this is dealing with an SMSF trustee. So my poll once more. Can a power of attorney act for an incapacitated SMSF trustee? All right, so this is a common arrangement. You might have mum and dad as trustees of their own SMSF. Either mum or dad loses capacity, but they've got an enduring power of attorney. Can their enduring power of attorney step into their shoes as a trustee? Responses are coming through, and at the moment we've got 44%, or 33% say yes, 67% say no. And I can see you've all taken on board my comments from earlier, and you've been good learners. You've realised that as a general proposition, trustees cannot have their attorneys make decisions on their behalf, except that they can when it comes to SMSFs. And it's a strange little carve out that we find in the SIS Act. Section 17A provides that a superannuation fund doesn't become non-compliant simply because you have an attorney acting for one of the trustees. The precise wording is there on the screen for you. The legal personal representative of a member of the fund effectively can become a trustee of the fund, or even a director of the corporate trustee of the fund, if that member of the fund is under a disability and Roman numeral 2, the legal personal representative has an enduring power of attorney that would allow them to act. And so if you just stop at section 17A subsection, 17A section 3, you would think that if one of the trustees is under a disability, they've got an enduring power of attorney, then that legal representative can make decisions on their behalf. But the Commissioner of Taxation has clarified the ATO's view on this section and says, well, that's correct, but it doesn't actually allow the attorney to make decisions on behalf of the trustee. Rather, the Commissioner has said, and this is in the Self-Managed Superannuation Funds Ruling 2010/2, the Commissioner has said that in order to comply with this, what happens is that the legal personal representative actually gets appointed as the trustee of the SMSF or as the director of the trustee. And so it's not that Dad's lost capacity, his attorney can start signing documents that Dad would have had to sign. No, what happens is the attorney can be appointed as the trustee of the SMSF and then can carry on the business of managing the SMSF. And so that's an important distinction. And if you're going to be have your SMSF remain compliant, then you need to pay careful attention to this. And so then that raises issues of, well, does the trust deed allow for replacement of a trustee in those circumstances? If you've got a corporate trustee, then not only are you going to need to comply with the trust deed, you're also going to need to comply with the provisions of the Corporations Act and any other relevant CIS Act or regulations there. But there is provision that even a non-member can be a trustee of the SMSF in these precise circumstances. Okay, we're getting to the pointy end, and I'll move things along here. Related to superannuation then, not about control of the trustee, but in relation to binding death benefit nominations. And here's the question for you. If you've got an incapacitated member, can their attorney make a binding death benefit nomination in respect of their superannuation benefits on the member's behalf? And I've given you a few options here now. We've got a yes, we've got a no, we have probably yes, probably no, and then for those of you who struggle with commitment, it depends. What do you think? Can an enduring power of attorney make a superannuation binding death benefit nomination on behalf of an incapacitated member? And here we go. This is very, very equally split across the board. A handful of people have said yes. One or two have said no. Some have said probably yes. Some said probably no. And a third of you just, it depends. The answer probably depends a little bit upon who you ask and where you are in Australia. And that might not sound helpful, but let me explain to you why. I won't read all of these to you. You can have a look at the slides later on if you're interested. But firstly, if you're in Western Australia, the West Australian State Administrative Tribunal said that making a binding death benefit is a testamentary act. It's akin to making a will, and that's clearly beyond the power of enduring powers of attorney. That was the West Australian decision, but that's only a state administrative tribunal. In Queensland, the Queensland Supreme Court, and has affirmed this on a number of occasions now, says that actually no, making a binding death benefit nomination is not a testamentary act. It's exercising a contractual right that you have with your super trustee. And so that's a financial matter. And so in the state of Queensland, attorneys can make a binding death benefit nomination. Then there was the New South Wales decision, which said it wasn't really clear which way it went. It said that the manager of a protected estate didn't have the authority to make a binding death benefit nomination, but they were very unique circumstances. They don't necessarily extend to attorneys. That was something like a guardianship order in New South Wales or the equivalent. And so it's subject to unique state legislation, state-based powers, and can't be really applied across the board. And then you have some jurisdictions like Tasmania, which are very helpfully made it abundantly clear and said that an attorney may exercise any power of the donor in respect of superannuation. And so, yeah, look, the answer really there then is that it kind of depends. It kind of depends. The answer really is that unless you're in Tasmania or in Queensland, the situation's not clear. And so this makes it messy when you've got a trustee maybe in one state and the member may be in another, and who knows. Because of that, there is a degree of risk. Anytime you have a attorney purporting to make a death benefit nomination or some decision in relation to superannuation, there is a degree of risk. However, steps can be taken to try to provide some clarity. And this can be done by way of the enduring power of attorney. Potentially there might be some scope for amending trust deeds in SMSF situations. just to make it clear what the attorney can and cannot do. What many people don't realise is that powers of attorney actually are very customisable. They're not simply off-the-shelf documents that you get off the OPA website. They can be tailored and amended to work appropriately in very specific situations. And, you know, for a lot of clients, that might not be necessary. But if you have clients who do have a little complexity to their structure, or maybe a little complexity to their family situation, then it can be appropriate. And so I'm going to hand over to my colleague Simran Joshi, and Simran's going to talk us through some of these possibilities to tailor and provide good solutions to clients. Thanks, Simran.
Thanks, Jason. Good afternoon, all, and thank you for joining us this afternoon for this webinar. So here I'm going to discuss today is matters of specific authority. Generally, when a principal appoints an attorney for financial matters, the attorney is able to act on behalf of the principal for all financial matters. However, there are certain matters that require specific authority within the power of attorney document. And as we go ahead, I'll go through each one of them and explain these matters with the help of a case study. First, I'll talk about conflict of interest. To begin with, let's take a look at the legislation. Jason, if you could move to the next slide, please. Thank you. So Section 64 of the Power of Attorney Act in Victoria prohibits the attorney to enter into transactions in which there's a conflict of interest and the duty of the attorney to the principal. So or anyone relating to the attorney. So that's prohibited by the Act in Victoria. Further, Section 63 of the Act talks about the duties of the attorney. So other than the duty to act honestly, diligently, in good faith, exercising reasonable skill and care, Section 63, 1C and D particularly say that attorney has a duty not to use the position for profit and must avoid acting where there's a conflict of interest. There's an exception to that. If the attorney is authorized by the PAR or by the principal or by a VCAT order. So with this in mind, let's take a look at our case study on the next slide. So this case study is based on a real life client situation. Of course, the names and some facts and figures are tweaked. Here are James and Pamela. They're a married couple in their mid to late 70s. They're married for 31 years. They're part of a blended family, with James having 2 adult children from prior marriage and Pamela 3 adult children of her own. In terms of assets, you'll note that nothing really is joint with them. Pamela owns the house in which they live, worth around $1 million. She has a sole bank account with a balance of around $250,000. Some shares around 33,000 again in her sole name. James has a super balance of around 500,000, and for this he has nominated Pamela as the beneficiary for the reversionary pension. He has a meager balance of around $1,500 in his bank account in his sole name. In terms of their current wills, everything they own in their individual names goes to their respective children, with Pamela giving a life interest in the house to James, which after James' passing will go eventually to her children equally. So what's more is that through their power of attorney, they appoint each other as their attorneys and their respective children as backup attorneys. What is noteworthy is there's no specific authority in the power of attorney that has been given for any matters. Now, let's assume in this situation, Pamela loses mental capacity and has to move to assisted care. Now, in order to fund the deposit for the care, since James needs that money for making that deposit, James withdraws all of his super and he pays that deposit. So since he himself has meager amount in his bank account, he needs funds for his expenses. And being the attorney for Pamela, he accesses Pamela's bank account to withdraw the funds for his sustenance. Now, this is a conflict transaction. In his position as attorney, he's not allowed to benefit. The other conflict that happens is he continues to live in the house, and note that is owned by Pamela, and there's no specific authority in Pamela's power of attorney allowing him to do so. So both of these are conflict transactions that are not allowed under the Act and can have consequences. So what happens? Pamela's children, who are not on good terms with James, they seek legal advice, and they move VCAT to claim compensation under Section 77 of the Power of Attorney Act from James for acting in contravention of the Act. So this could have been clearly avoided. What could have been done? So if James and Pamela would have sought specialized estate planning advice at the time of getting their will and powers of attorney documents, and by giving instructions for specific authority in the power of attorney document, allowing for these conflict transactions between the spouses. So what we generally see in our practice is mostly spouses appoint each other. And this kind of a situation can be avoided if there's specific authority given by spouses, at least to each other, if not to the backup or the other attorneys who are appointed. Okay, moving on to another matter. This is relating to superannuation, for which a specific authority in the power of attorney is required for the attorney to act. So let's just tweak our James and Pamela case study a bit. And so instead of James nominating Pamela as the reversionary beneficiary, he does a binding death benefit nomination in favor of the estate. Now, why does he do that? He does it because he wants his superannuation to go to his children through his will. So let's assume this time that not Pamela, but James loses capacity, and he's incapacitated. While he's incapacitated, the binding death benefit nomination lapses because it's a lapsing one. Most of the retail industry funds have a 3-year lapsing period, and it lapses on completion of the 3 years. So what's the result? When James dies, it's up to the trustee at their discretion to pay the death benefits. So the trustee might pay to Pamela or to the children or to the estate. So it totally depends on the trustee. If the trustee pays to Pamela, it defeats the entire intention of James to actually, have the benefit paid to the children. So what could have been done? Again, specific direction or power to the attorney could have been given in the power of attorney document to allow the attorney to renew the binding death benefit nomination to prevent it from lapsing. Now, what needs to be noted is if it was an SMSF, a self-managed super fund, the super deed should permit that. So that needs to be ensured. That is, if the principal has lost capacity, it should permit that the attorney has the power to renew the binding death benefit nomination on behalf of the principal. If it doesn't give that power, then maybe consider a variation to the super deed. Another express authority relating to the super that could have been given through an enduring power of attorney is the power to withdraw the super if the principal is terminally ill. Now, though it is quite possible that the attorney will be able to do that without express power, but having an express authority will ensure that the death benefits are paid out by the super trustee without any delay. So that will be worthwhile to put that kind of a express authority within the power of attorney document. Now, there are a few more matters that I will briefly touch upon. In terms of gifts, Now, the legislation permits gifts subject to a number of restrictions. Now, Section 67 of the Power of Attorney Act says that the gift needs to be reasonable. It has to be to a relative or close friend of the principal, has to be of a seasonal nature or for a special event. And if it is made to an attorney or someone related to attorney, and if the total gift value of the gift is above $100 or the prescribed amount, then it needs to have a written record. So all of these restrictions are there if the gift is made. So it is best to give some kind of an authority to the attorney if the gifts may fall outside the scope of the legislation. Further, the Act does not permit remuneration to attorneys. So most of the time, professional attorneys are appointed, so they need to be careful about that, because then they need specific clauses in the power of attorney to be able to receive a remuneration. Lastly, authority to see will. The attorney has no authority unless specified to see the principal's will. So when does a situation arise when an attorney will need to see the will? So if the principal has given certain property as a specific gift, maybe through his will, and the property is subject to a life interest, then it is best to give authority to the attorney in the power of attorney to see the will. Now this is for the reason that so that the attorney doesn't sell the asset, and that may lead to redemption of the gift in the will. So in all of these matters, it's best to have a specific power in the power of attorney. So moving on to some practical tips that can be taken care of. This is a bit of a recap and a list of examples and limitations and conditions. So in terms of limitation, there are certain assets. If they are not supposed to be sold, it's best to put those specific authorities or specific limitations in the power of attorney. In terms of condition, these are certain examples, like to provide information to or consult another trusted person by the attorney, and there may be an independent assessment of the decision-making capacity of the principal. There are certain situations where the principal might want to say that another person be notified before the power of attorney is first brought into effect, or a certain transaction value is more than a certain amount, then a certain person need to be notified. As I'd already discussed about the examples of specific authority, this is just a recap of those. So allowing, again, conflict transactions for specific people, mostly in case of spouses, power to see the will, power to renew or alter the binding death benefit nomination, and withdrawing superannuation on meeting the condition of release, maybe in case when the principal is terminally ill. That's the example that we saw in the case study. Also disclosing confidential information. So if in case of medical or personal information, there can be specific authority in the power of attorney allowing the attorney to disclose confidential information about the principal, and specific authority relating to gifts, and lastly, authorizing the payment of remuneration. So I'll now hand over to Jason for the last bit of the presentation to discuss how to mitigate the risks to advisors, and for his concluding remarks.
Thanks very much, Simran. And we've intentionally, obviously we're covering a lot of material here today, and we're trying not to get too bogged down, but we're intentionally leaving a lot of time for questions because we want this to be as relevant to your practice as we can. So if you do have any questions, you're welcome to start thinking them, formulating them, pop them in the question and answers box there on your screen, and in a moment we'll get to some of those. We've got some there already. So We will endeavour to answer those as best we can. But as you can see, this is can be a very highly and complex area, and it will really depend upon the circumstances. It's very rare for any one family situation to be identical to the next, and particularly as we see, more and more blended families, that's probably where nine-tenths of these issues arise, and the scope and possibility for conflict is high. And so making sure that some of this thought is given prior to those circumstances arising can go a long way to avoiding the issues. But not only are these issues for your clients, for the families and the individuals and groups involved, they're also issues for us as professional advisors, for you as professional advisors, as you work with clients and situations. I was talking to one of my partners here just this morning, and she mentioned a situation she came across where the clients couldn't understand why the financial advisor was talking to the daughter and not to them. And turns out that the financial planner just presumed that because there was an enduring power of attorney on file, that the daughter was the one calling the shots. And in fact, the conditions for commencement of that enduring power of attorney had not even been satisfied. That it was just a piece of paper as far as the parents and the decision-making authority were concerned. And so things like that can really be risks to you and to your business. We've got here just a couple of suggestions that might assist you in mitigating those risks and guarding against some of those things which can arise. The first suggestion here is to ensure that if you are dealing with attorneys, and that may be a general power of attorney, it may be an enduring power of attorney, but make sure that you actually have recent and correctly certified copies of that document on file. Now, I fully understand, the pressure when someone calls and dad's in hospital and mum's unwell and we need to do this quickly and we've got to get the shares sold and quickly, can you make this all happen? But overlooking this can leave you exposed to considerable risk. Not only do you want to make sure that it's relatively recent, I would caution you against relying on a copy that is 10, 15 years old. Make sure you've got something a little bit up to date, just in case mum and dad have changed that power in recent times. There's no particular time limit that I would say you have to have, but if it's getting a little long in the tooth, just ask them to get a fresh copy, just to confirm that they do currently still have the authority that they say they do. And also make sure that it's been correctly certified. Unbeknownst to many, buried in the provisions of the Powers of Attorney Act, there are specific rules for certification of copies of enduring powers of attorney. They're different to just the standard certified document process, and there are a couple of exceptions, but broadly speaking, they need to be certified by a witness who's authorised to witness affidavits, oaths and affirmations. So make sure you've got the right document. That's a really good start. Secondly then, as you work through it, make sure you understand precisely the role that each person plays in this drama. You know them as mum and dad, as your client, you've had them for years, but are they acting as an individual? Are they acting as a trustee? Are they the director of a company? Are they the director of a corporate trustee? Are they the trustee of an SMSF? They, as you well know, they frequently will have many hats, but as we've seen from this presentation today, their attorneys will only be able to act for them in some of those roles. And so you need to very carefully pass the situation, sift through and figure out who is actually authorised to do what. And that really leads to the next point then, because you're going to be going to the documents every time. You're going to be reviewing the trust deed and find out does it actually say what happens when a trustee loses capacity? Who has an alternate power of appointment if there is one? Is there a specific direction in the Constitution? What happens? check the actual authorities that are in the enduring power of attorney. And again, as Simran has outlined, some of the potential specific authorities or limitations that could go into an enduring power of attorney. Make sure that the attorney, as you give advice or act on their instructions, is acting within the scope of those authorities. For example, I've seen enduring power of attorney that limited the decision making to transactions under $20,000. It would be very easy for you to just overlook that and forget and give effect to some share transaction, share sale or something that would exceed that authority. And the problem with that then is that the transaction's been made without authority. As you manage the risks, you may recommend to your clients considering amendments to their enduring powers to include specific authorities, to include some of the things that Simran's outlined there. If, as you go back through your files after lunch here today and you remember some matters which have gone through and you look through and you realise that maybe an attorney has somehow exceeded their authority or has relied on documents which weren't properly executed or something like that, there is some opportunity to apply to VCAT in certain circumstances to rectify, ratify, or remedy those issues. And VCAT has very, very broad power under the Powers of Attorney Act to review decisions that have been made, to review compliance with formal requirements, even to advise administrators as to the proper carrying out of their duties. And so that might be something to consider. As I said at the beginning of this presentation, it's easy to think of powers of attorney as being a relatively inconsequential area. But as you think about it and think about some of the things we've discussed, I was just sort of jotting down what's actually at stake, what are real world risks are we talking about? And just things that sprang to mind was the possibility of years worth of invalid discretionary trust distributions paid by an attorney who thinks they're acting on behalf of the trustee. And you accountants in the room will be able to tell me the tax consequences of that happening. You know, the possibility of litigation in blended families over unauthorised conflict transactions. The risks of attorneys inadvertently being treated as shadow directors. The risks of an SMSF being non-compliant and being assessed by the ATO as such. And so, you know, these are potentially risks to you as advisors if you've played along without noticing or advising. So these are just some of the issues that can arise in relation to powers of attorney. There are many general principles which many of you are familiar with, so we've not addressed those today, but we've specifically wanted to highlight some of these maybe more obscure issues, but ones which can present very real risks. We've got one or two questions here. If you have any other questions, please feel free to pop those in. But we'll do our best to answer these, and if we can't, we'll give you a response separately. Brett asks, what happens if a donor becomes bankrupt? Can the power of attorney represent the bankrupt? The answer that comes to mind, Brett, and Simran, jump in if you've got another view, it depends largely upon the role that the principal has. And so this will be different from area of responsibility to area of responsibility. So, for example, in the Trustee Act, a trustee cannot be bankrupt. So if they become bankrupt, then they're automatically disqualified. Now, as we've established, a power of attorney can't step into that role automatically, but there may be some provision in the trust deed that would allow for an alternate trustee or have some direction about what happens if one of the acting trustees becomes bankrupt. And so you'd have to sort of break it down generally. But in relation to the individual's personal financial matters, then I would have thought that no, the power of attorney wouldn't take control of that individual's affairs, because the trustee in bankruptcy would. And so the trustee in bankruptcy's power would certainly eclipse that of the power of attorney. So another question here. If an employee loses capacity, can their attorney turn up to do their job? That's a great question. The answer would be no, but I'm just trying to think of the reasons why. And I suppose it's because generally employment calls for personal performance of obligations. And so that would be unique to the employee, not their attorney. In any event, I can't imagine too many employers who would want the random attorney showing up and trying to perform the job. I suppose depending upon who the attorney is. Simran, you might have an answer for this one. In relation to a family trust, can the attorney for the appointor act on behalf of the appointor and replace the trustee? Excellent question.
Sorry, I can't see the question. Just a moment.
Oh, sorry. So the question there is, this is talking about a discretionary family trust. If there is an appointor and that appointor loses capacity, can their attorney act and exercise that power of appointment and replace the trustee?
Yes, can do so. Sorry, I misread the question. No, the appointer cannot act on behalf of the attorney cannot act on behalf of the appointer of the trust. Yeah.
I think that yes, that power of appointment is another personal exercise of power that would similar to the trustee's exercise of power. Again, it would depend what's in the trust deed, and in some cases, specific powers can be assigned. So even if it's not by way of the power of attorney, an appointor may be able to assign their power of appointment to another person or to more than one person. So there may be other ways of skinning that cat, but prima facie, no, power of attorney wouldn't provide for that. Another question here, Simran, is about ademption. Could you just briefly touch on the issue of ademption and how that relates to this topic?
So when a specific gift is given in through a will by a person, there's a chance that before the will comes into effect and the person sells the asset, then the rule of ademption comes into effect. And since there's no gift left, the specific gift cannot be given, and that's so the will cannot take effect with respect to the specific gift. So if in the power of attorney, the attorney is given a specific authority in terms of looking at the will, or giving authority in terms of seeing the will, then the attorney knows that the will have the specific gift has been given through the will, and then can make sure that the will doesn't he doesn't sell the asset, or if there's a life interest, then he does not touch the asset.
And again, if in a simple family situation where everything's just divided equally between the kids, ademption is not such an issue. But if you have will makers who want to make sure that a specific asset goes to a specific person, then those specific assets are subsequently sold, then those people may miss out. So ademption can be a serious issue.
That's right. Yeah.
Thank you everyone for those questions. I think we've covered them all. Brett, Con's got some further good commentary there for you, so I'm sure that you insolvency guys can have fun with that after we're done. But thank you for being with us today. If you do have any other questions about these or other issues, don't hesitate to give Simran or myself or any of our team a call. We're always happy to have a chat and see if we can be of assistance. But that's all from us, I think. Deb, I'll pass back to you. Thank you.
Thanks, Jason and Simran. I hope everyone enjoyed today's presentation. Just finally, I just want to take the opportunity to promote our next webinar coming up on the 19th of June, presented by Con, and the session is When Paying the ATO Means Twice the Pain. Registrations will be open in the coming weeks, and as an attendee today, you'll be notified when it does open. And as I mentioned earlier, we would like your feedback, so please take a couple of moments to complete a short questionnaire. You can access it via the following link there, or also use your QR code on your phone. Thanks everyone for attending today. Enjoy your rest of your afternoon.